Thank you. Good morning, everybody, and you're very welcome to the meeting of Licensing Subcommittee, 28th May 2022. My first task is the election of chair, and as the chair of the Licensing Committee, I'm deemed to be the presiding person for this meeting. Therefore, I'm looking for nomination for chair. May I hear a nomination for chair, please?
I nominate yourself, Councillor Batt, as chair.
Thank you very much, Councillor Bagwell. May I have a seconder?
Yes, I'm happy to second.
Thank you very much, Councillor Williams. So we'll now move on to housekeeping, and I'll ask my clerk, Mr. Tyler, would you kindly read out the housekeeping? Thank you.
Thank you, Chair. Please note that this meeting of the Council's Licensing Subcommittee is being recorded for live and subsequent broadcast and may be published on the Council's website for a minimum of 6 months. Please can everyone present follow these ground rules for speaking. Please only speak when invited to by the Chair. For those joining us via Microsoft Teams, please utilise the raise your hand function to speak if you want to draw the Chair's attention and speak on a point. And please do ensure that your video function is enabled when you do speak. For those of us in the room, if you want to speak, please use the microphone on your desktop and ensure the red light is showing to show that the microphone is working. This is important for the live stream and the purposes of those joining us remotely to be able to hear. Finally, for those of us in the room, if the fire alarm sounds, please exit by the nearest available fire exit and make your way to the multi-storey car park, which is the fire assembly point. One final point is just to make sure that all mobile phones and other devices are switched to silent for the duration of the meeting. Many thanks, Chairman.
Thank you, Mr. Tyler. Okay, so moving on, item 2, which is apologies. We do have apologies from Councillor Kelsey. We're very pleased to welcome Councillor Bagwell as the first reserve, who's popped up there. Thank you very much for attending. And moving to reserves, we also have 2 reserves in place, who are Councillor Slade and Councillor Burton. Thank you very much for your attendance. This is a face-to-face meeting. We are all in situ, so you won't be needed, but you will be needed to be available for the next remote. But you are free to stay or free to go home and tune in, and we will see you a little later with the second item. Thank you very much for your attendance. So any declarations of interest? I'll ask in turn each councillor. Do you have any declarations of interest, Councillor Bagwell?
No, not any.
Thank you. And Councillor Williams?
No, I have none.
And for completeness, I have no declarations of interest. So item 4, protocol for public speaking. Please note that the protocol for public speaking has been circulated with the agenda at agenda item 4 in its entirety and is available to everybody here and the public. So then on to the substantive, which is item 5, and it is Wiggle. And it is 159 Old Christchurch Road, Bournemouth. And an application has been received for the renewal of the sexual entertainment venue licence to permit relevant entertainment to continue for a further 12-month period at the premises known as Wiggle. This matter is brought before the subcommittee for determination. So in order to start proceedings, we will all introduce ourselves and we will state our role. And I'd be grateful if subcommittee members would state their ward, please. So my name is Councillor Jude Smutt. I'm chair of the Licensing Committee. I'm also chair of the Licensing Subcommittee for the purposes of today's business, and my ward is Creekmore, Hilborn and Waterloo. Thank you. Councillor Bagwell.
Thank you, Chair. I'm Councillor Julie Bagwell. My ward is Hamworthy, and I am Vice Chair of Licensing. Thank you.
Thank you very much, Councillor Bagwell. Councillor Williams.
Hello, I'm Councillor Lawrence Williams. I'm a member of the Licensing Board, and I represent Littledown and Iford wards.
Thank you. And our reserves today were Councillor Slade from Broadstone and Councillor Burton from Canford Heath. So moving on, all those from the council. So firstly to ask Mr. Joe Tyler to introduce himself.
Thank you, Chair. Joseph Tyler, Democratic and Overview and Scrutiny Officer, and I am clerk for today's meeting. Thank you.
Thank you. Sarah Rogers.
Good morning, Sarah Rogers, Senior Licensing Officer for BCP Council.
Thank you. And Joseph Cannon.
Hello, good morning. My name is Joseph Cannon. I'm a barrister in independent practice, but I'm acting as a legal advisor for the council today.
Thank you. And Nikki Hooley.
Thank you, Chair. Democratic and Scrutiny and Overview Officer. I'm just here to take notes today and deal with attendee, but won't be participating in the meeting.
Thank you very much, Ms. Hooley. John Walsgrove.
Good morning, everyone. John Walsgrove, and I'm solicitor for Wiggle.
Thank you very much, Mr. Walsgrove. And Mr. Ouija and Mr. Ouija, the two Mr. Ouijas.
It's Jaspal Ojala.
Ojala, I have it. Okay.
I'm the MD of Wiggle.
Okay. You're very welcome this morning. Thank you. And we have Councillor Northover.
Yes. Hello.
Did you want to state your ward, Councillor Northover?
Oh, Muscliffe and Stratton Park.
Right. You're very welcome this morning. And we don't have Councillor Dunlop with us yet. No? Okay, well,
Don't know.
We'll allow her in as soon as she arrives. Thank you very much. So I ask that all persons who've given notice for their intention to speak have been identified as of today, and any person who wishes to withdraw representation or wishes not now to speak to identify themselves. So I'll just look for any show of hands. Yes, then Miss Randall, I forgot you. I am so sorry. You're not on my list. And Mrs. Randall, would you like to introduce yourself? Because you're so insignificant, of course. Please introduce yourself.
Thank you. My name's Nananka Randall and I'm the interim head of licensing for BCP Council.
Thank you very much, Mrs. Randall. My deepest apologies. So if everybody wishes to continue to speak as identified, I can't see any hands showing. Thank you very much. So we'll go now through the process as to how the hearing will proceed. The licensing officer will present their report and the applicant will make their application. Questions of the applicant by all parties and members of the subcommittee will go first. Responsible authorities and other persons will make the representations. We don't have any responsible authorities, but we do have other persons with regard to our two councillors present. The questions of the other persons with members of the subcommittee to go first. All parties will then be given an opportunity to sum up with the party who spoke last to go first, and the hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and clerk present. We will deliberate directly after the hearing. And notification of the subcommittee's decision will be given within the period of 5 working days, beginning with the day or the last day on which the hearing was held in accordance with the regulations, and that will be today, the date being the 26th of May. And the notification decision will include information about the right of appeal as appropriate, and we will be asking our legal advisor to give information with regard to that right of appeal at the time. So I'm just going to check that all parties are content with that procedure, and then we can continue. Sarah, Mrs. Rogers?
Yes, I'm content, thank you.
Thank you. And Mr. Cannon? Are you content with the procedure, Mr. Cannon?
Sorry, yes, I am. I indicated physically, but I should have put my microphone on. Yes, I am.
You are, yes, it is hard. Do try and remember to pop your mic on, but you'll soon be reminded you haven't by your puppetry when we can't hear you. Thank you very much. Mr. Walsgrove.
Yes, that's fine. Thank you.
Thank you very much. And Mr. Ojala, the Misters Ojalas, are you both content?
Yes. Yes.
You are indeed. Thank you. And Councillor Northover? Are you content with procedure? Have you got your mic on?
I am, yes. Can I just check if I am down to speak? Yes. Right.
Oh, indeed. Yes, you are indeed. Yes, as another person, Councillor Northover. Don't worry. I'll bring you in when necessary. All right. You'll have your opportunity. Please don't worry. And Councillor Dunlop isn't with us, but I'm sure she'll join us soon. Okay. And finally, and most importantly, I just remind all parties speaking not to repeat the information which they've already given in writing, but to expand on their written representations. All questions to be asked to the chairman, and no temptation, please, for cross-examination of parties. So I'll now ask Sarah Rogers, please, if you'd like to present your report. Thank you very much. I am correct. It is Sarah, isn't it? Yes, Sarah Rogers, if you'd like to present your report. Thank you.
Thank you very much. This application is made by Well Hot Limited for the renewal of the sex establishment licence held at 159 Old Christchurch Road for a further 12-month period. The application made complies with the relevant legislation. Newspaper notices were published in accordance with that. As a result, 3 objections were received. However, 1 was refused on moral grounds. The other 2 have been received from local ward councillors. No objections were received from any responsible authority as we describe, as we identify under the Licensing Act, as we consulted them also. The premises have been operating as an adult lap dancing club for the past 16 years, since they took over in 2006, when the premises were operating as a cabaret restaurant. They've had the benefit of a sexual entertainment venue licence, permitting the performance of nudity, following new legislation which came into effect in April 2010, which gave more control to local authorities and residents over the operation of these premises. Further information in support of the application has been provided by the applicant and has been distributed prior to this hearing. And that includes 2 video clips, which I believe we're also going to see. And that's it from me. Thank you very much.
Okay, thank you very much. So are there any questions, please, with regard to points of fact for Mrs. Rogers? Members?
Not from me.
I have one question for you, Mrs. Rogers, with regards to the premise. Have you been able to conduct a joint enforcement exercise with the responsible authority, which I believe would be the police?
Yes, in December last year, myself and my colleague accompanied Sergeant Gosling from the licensing police, and we did a compliance check of all 3 SEV premises in Bournemouth. We found them to be largely compliant and operating responsibly. We did have calls to refer Wiggle to the fire service because at the time of our visit there was an alert on a fault on the fire alarm system. They attended soon afterwards, and they have confirmed that at the time of their visit the fault was no longer showing. They did check the fire risk assessments and were pleased with what they found and confirmed that the premises were fully conversant with all the emergency procedures and had undertaken training. Therefore, they had no concerns.
That's very good to hear. So all full compliance at this stage, but unfortunately not at the time of your visit. But then, of course, your visit's are for that purpose. So thank you very much for undertaking that and for dealing with the issues that arose from that. Thank you. So any questions with regard to points of fact from Mr. Walsgrove?
No, thank you, Chair.
Okay. And any questions, points of fact with regard to the 2 Mr. Ojalas?
No, thank you.
No, thank you very much. Councillor Northover?
No.
Thank you. And we don't have Councillor Donald with us just at this moment. Thank you. Okay. So now it's the opportunity for the applicant to make their application. And Mr. Walsgrove, you're making the application on behalf of your applicant. If after your representation the applicant wishes to add something, I'm more than happy to hear from them. So Mr. Walsgrove, you have the floor.
I'm grateful, Chair. Thank you. Well, as you've heard from your licensing officer, it's an application for renewal of the SEV licence, and it's in identical terms to that which has been granted over many years. You'll see and have heard, in fact, from the report that it's operated as that type of venue since 2006 and been licensed when the new legislation came in. Just by way of background, Mr. OJ has other SEV premises across the south coast, so 2 in Portsmouth, 1 in Southampton and 1 in Weymouth. First opening in Portsmouth over 20 years ago, and in each case has applied for the relevant licence and has had it renewed in each of those local authority areas for decades now. In terms of the presentation, I'll split it into 4 effectively. I just want to talk about the statutory provision first, so the legality of what considerations you will be taking into account under the statute. Then to have a look at your policy and what that says about this application. The third thing is just to have a look at the case which has been referred to by Councillor Dunlop in her representation, as in my respectful submission, I think that has been misleading in terms of what that case said and what it's about, and I think you need to understand better the facts of that case so that you can properly put into context some of the judge's comments which have been quoted in that objection. And lastly, fourth part of the presentation is just to make some general comments about the two written representations and the issues that they've raised. In terms of the two video clips that have been mentioned, my client just took those just purely to give a flavour of what is a typical night out in Bournemouth. I'm not. It's not necessary that you see them because you've probably got your own local knowledge, but obviously he took the videos. If you want to see them, you're more than welcome to. It just shows how busy a night out it is in that location, and that it's not a quiet residential hub. It is a nighttime economy commercial street with several licensed premises, which Mr. OJ has produced that report setting out where all the licensed premises are and also what planning applications have been made, and I'll refer to that in due course. So it's entirely a matter for you. If you want to see the video clips, they're very short.
Can I just stop you there? Can I just stop you there, please? Just looking through the pack, we do have the map, we have the location plan. You made reference to a video. I take it this is something you're wanting to submit now, Mr. Tyler?
Thank you, Madam Chair. The two videos that were received from the applicant did come in, and the request was made for them to be shown in this meeting. If the subcommittee wished to see those two short clips, we can do so. I have had correspondence with the barrister to say that there could be members of the public identified from those videos. So if it was the subcommittee's wish to see them now, just to let you know that we would have to go into exempt session for that. Right. So I'll leave it to you.
Thank you. I think actually, Mr. Walsgrove, we all live in the locale. We know our locale well. We do know the area very well. I don't see the need with respect, but I will ask my subcommittee members, and if that is the case, then we will go into exempt, because we cannot have members of the public identified without, obviously, with regard to GDPR and their concerns. Councillor Bagwell, your thoughts?
I think with all the paperwork we have and the barrister's words and everything and the applicants, I don't see as we
You're
need
content.
to.
Thank you very much, Councillor Bagwell. Councillor Williams?
Yes, I'm also content.
Okay, right. So we've explored that then, Mr. Walgrove. So on this occasion, we feel content that we have that information available to us. So if you'd like to continue, thank you.
Grateful, Chair. Thank you very much. So dealing with the first part of the presentation then, the statutory position. So under the legislation, a committee has two sets of grounds on which they could refuse to renew the licence. There are mandatory grounds and there are discretionary grounds. And just for the sake of completeness, I'm just going to run through what the mandatory grounds are. They haven't been referred to in your report, but I just want to make sure that this committee has considered everything they should do so that there's no stone unturned, so to speak. My contention is that none of these mandatory grounds are relevant, but I just will take you through them very briefly. So, first
Mr. Walsgrove, again, I can stop you there. We furnished ourselves with these mandatory grounds, thank you. With regard to licence not being granted to a person under the age of 18, etc., etc., they're very kindly provided to us. I can quickly pop through the mandatory grounds so that you are in agreement that we have been versed with them correctly. But there are 5 points. Starting licence must not be granted to a person under the age of 18, to a person who is of the time being disqualified due to the person having had a previous licence, etc., to a person other than a body corporate who is not resident in an EE state, etc., and also to a person who has, within a period of 12 months immediately preceding the date when the application was made, later refused the grant or renewal, etc. Are those the mandatory terms? Because if they are, then we can take it as read that we do understand those. We also have discretionary grounds, of which we also understand and have had access to, that the applicant for new renewal or transfer of licence is unsuitable to hold licence for reason of having been convicted of an offence, etc., etc. And again, there are 4 heads of case. So if they are identical and you're content that you're happy we've understood them, can we continue?
Yes, Thank you, Chair.
Thank you, Mr. Walsgrove.
So in my submission, the only relevant ground, the only ground on which you could refuse this is the discretionary ground that it wouldn't be appropriate having regard to the character of the locality and or the use to which premises in the vicinity are put and or the layout, character or condition of the premises, and none of the other grounds apply in this case.
Thank you, Mr. Walsgrove. And for the purposes of clarity, members, that's the last bullet point in our list. Okay, thank you, Mr. Walsgrove. If you want to continue.
I'm grateful. So why do we say that the licence should be renewed? Well, we say we can put forward credible evidence that the character and location of the premises is one in which it's suitable for Wiggle to be licensed. As you've heard, it's been there for the last 16 years, and in fact very little has changed with regard to that locality. As I said, it is an important part of Bournemouth's nighttime economy, and you yourself have said you've got your own local knowledge about how busy it would be on a night out in that location, and my client has produced a comprehensive document which sets out all the other licensed premises within a very short space of time, and also did quite a lot of research on what planning applications have been made since the last renewal of this licence, just to show you that it has not changed to any great degree whatsoever. So principally in terms of what we put forward, you've heard there are no objections from the responsible authority. So certainly of great note there would be the police in relation to crime and disorder and your own licensing team and environmental health. There hasn't been any objections from any local residents. There weren't any objections to the renewal whatsoever last year. It was renewed, as I understand it, under delegated authority. No hearing was required. But again, residents who are within the vicinity of Wiggle have not raised any concerns with this committee. It is in that commercial nighttime economy area, and you have before you no evidence to suggest that the operation of Wiggle is having any adverse impact either on the amenity or community, or more importantly crime and antisocial behaviour, which is alleged by both the councillors in their representation. Had there been the concerns and credible evidence available, then I'm sure the police would have made a representation against the renewal. So the last 12 months have run without any issues. There's absolutely no suggestion or credible evidence before you that would suggest that if you renewed the licence that there would be any negative impact on the local community from the operation of these premises. One thing that I would say is that the sexual entertainment venue premises are of course much more heavily regulated than any other licensed premises in the nighttime economy, with much stricter conditions regulating the SEV than a normal licensed premises. And it is considered generally, so I've had feedback from police from each of the areas that Mr. OJ operates in to say that in fact those venues are the safest venues in the nighttime economy, and indeed people will go to those venues for that reason, not necessarily for the entertainment being provided, but because it does provide a safe environment to have an evening out. So moving on to just have a look at your policy, and obviously the SEV policy is quite recent, November 2020, and I made the point that it was obviously put before the full council for adoption. And there are just some specific paragraphs of that policy which I would like to draw to the committee's attention. So I don't know whether you have the policy before you, but I'll just read out. There's only 4 or 5 paragraphs I need to refer you to within that policy. But on the second page of the policy, paragraph 1.6, it says that the council does not take a moral stand in adopting this policy. It recognises that Parliament's made it lawful to operate a sex establishment, and that such businesses are a legitimate part of the retail and leisure industries. BCP Council will, as a licensing authority, administer the licensing regime in accordance with the law. So moving on further down the same page at paragraph 4.1, as I pointed out, the policy was presented to the full council for adoption. So that's what that paragraph says. Moving on, turning the page to page 3 at paragraph 5.1, it's important to note this policy supports the BCP Council core strategy. So I think Councillor Dunlop has raised in representations the implication that this wouldn't be part of the council's sort of future planning or strategy, and the character of that locality may change in the future. Certainly there's no certain that it has done in the last 12 months. But I want you obviously to attach weight to your policy, that you've adopted it, it's been adopted by the council and it follows the council's core strategy. And most significantly, none of the local residents have raised any concerns about this venue. So moving on the policy at paragraph 10.1, which is on page 7, that paragraph reads as follows. It's acknowledged there are currently 3 licensed sexual entertainment venues within the Old Christchurch Road and the Elverton Road areas of Bournemouth Town Centre. These are For Your Eyes Only, Wiggle and Spearmint Rhino, and that these venues have been licensed for a number of years. The rest of paragraph 10 then goes on to set out why the consideration of those 3 premises will be considered differently by this committee. And at 10.4, it reads, it's been determined that these existing licences will continue to be renewed on application by the existing operators during the lifetime of this policy, which is up to 2025. If there are any objections to an application, it will be considered by the committee in accordance with the relevant statute. This essentially provides grandfather rights to these existing operators in the current time. So I'm asking you to attach considerable weight to that policy, that licence for Wiggle will be renewed at least until the policy is reviewed to 2025. So that's adopted by the committee that's sitting today, and it's been adopted by your full council. Those points are particularly important to make in light of the representations about the case of Thompson, which Councillor Dunlop has referred to, which essentially says in her representation, you don't need any change of circumstances. You can just refuse a renewal of the sexual entertainment venue licence. And I think it's important that you're aware of the facts of that case and why it was the council came to a different decision, which was then upheld on appeal, because the background to that case will make it clear that there was very substantial new evidence on the renewal which justified the refusal, whereas in this case there isn't any evidence whatsoever adduced by either councillor which would raise any concern on which you could refuse this application on those discretionary grounds. So in the case of Thompson, which was up in Oxford, they had a sexual entertainment licence venue and applied to renew the licence. But the council's policy had changed from the previous grant of the licence, and in accordance with that policy, the committee then refused to renew his sexual entertainment venue licence. He judicially reviewed that decision, but subsequently withdrew it because he found another location and the committee granted him a new sexual entertainment venue licence for the other premises. So he then operated his venue at this new location for a period of 12 months and applied to renew that licence. However, the committee refused to renew it after that initial 12 months. And so the licence holder sought judicial review, which was refused, and the matter ended up in the Court of Appeal. And the issue around the case as to why it was refused, and the facts are set out within that case, is that during the 12 months of the initial operation, the people who objected, and there were over 100 residents' objections, people who objected put together credible evidence that showed that actually his new club had had a really negative impact on that local area. And in particular, a survey was conducted where numerous women were interviewed about how the opening of that club had impacted, in particular on the ice rink, which was virtually next door to this new SEV licence, and obviously attended by families, young children and women. And although the judge had concluded that you don't need to demonstrate that something has necessarily changed in order to refuse a renewal, and that's the underlying principle on which Councillor Dunlop relies, it is authority that you have to have due regard to the fact that the licence was previously granted, and that if you decided to then go on to refuse it, you must give very clear and cogent reasons. But the most striking part of that case is the wealth of new evidence that was available to the committee saying, well, we've reviewed how you've got on over the last 12 months, and actually all of this new evidence, which we didn't have before us before because the place wasn't even open, we've now been able to assess what a negative impact your club has had on the local environment and the character of that locality. You don't have that in this case with Wiggle. You don't have any evidence from either councillor which suggests that it has had a negative impact on the local community. The vast majority of Councillor Dunlop's representation is a moral one. Much of it is cut and paste from a pressure group called Not Buying It, who actually opposed Mr. OJ's licence in Portsmouth, as they do virtually every year, and make the same comment about how inappropriate it is to have venues licensed for women to work in that environment. None of that is relevant, and your policy makes it clear that you don't consider any moral ground to be relevant. So I'm sorry that took a while just to explain that case, but given that no summary of that case was provided with Councillor Dunlop's representation, and in my view she misrepresented and has taken the judge's comments out of context, I thought I needed to explain in some detail what the differences are between that case and this one. So in conclusion, I would just say Wiggle is a very well run establishment. It's been within your local authority area for 16 years. No concerns have been raised by any responsible authorities. Mr. OJ is a responsible operator. He's got 4 other premises which have to go through the same process of renewal every year, and every time they are renewed. But overriding all of that is your policy, which clearly states that his licence will be renewed until 2025. And in my view, there would have to be something exceptional in terms of credible evidence for you to go against the written policy. So I'm obviously going to leave my presentation there. I'm happy to answer any questions. And obviously my client is there if you've got any questions about the operation of the premises. So thank you for your time.
Thank you very much, Mr. Bosgrove. Just to remind your good self and everybody here, this isn't a court of law. This is a hearing, so I do not wish us to get too wound up in legal semantics. We've heard from you with regard to argument. We have had a briefing with regard to Councillor Dunlop's overall views, and obviously we've sought those to ensure that we have clarity as to where things are appropriate to locality and as to where they're not, and where they may be moral or where they may not be. But with respect to what we have and what we do not have is materially down to us to decide and not your good self. And with that in train then, I will ask our legal advisor, please, if he has anything to add to your legal argument so that there's a balance. I think that's fair. Are we content, members? Yes, we are. Thank you, Mr. Cannon.
Thank you. Well, I'm not going to try and provide balance. I'm just going to give you some legal advice. It's not my role to provide an opposing view. And in most of what Mr. Walsgrove says, I agree with his analysis of the position. But let me just summarise what I think the law to be. Can I deal first with the policy? Because this is one of the ways in which I don't agree with the way that Mr. Walsgrove characterises things. So section 10 of the policy, and I just pause to say that, councillors, you will know that the policy itself, the decision to adopt the policy is presently under a court challenge, but that isn't something that should affect the way you deal with it today or the weight that you attach to it. It was properly adopted, and until such time as that changes, and of course the council are defending via my offices as it happens that decision, then that's not something that should bear on it, and of course we don't need to get any further into that, I hope. But the particular part of the policy with which we're concerned here is section 10, existing licensed premises, and 10.4, and I'm just going to tell you the way I think that particular paragraph reads, which is it's been determined that these existing licenses, one of which of course is Wiggle, will continue to be renewed on application by the existing operators during the lifetime of the policy. But then this sentence, if there are any objections to an application, it will be considered by the licensing committee in accordance with the relevant statute. Now, that's the position here. There have been objections, and you are considering it in accordance with the relevant statute, which is the 1982 Act. So the position that we're in here is, had there been no objections, that sentence wouldn't apply and there would be an expectation of renewal. But because there have been objections, it is an open question as to whether you renew it or not. So that's the way that paragraph of the policy works. That's the first point. That doesn't mean that there's a presumption against renewing. It just means that you've got to decide it according to the statute, which is what you're doing anyway. And as you've already heard, and I think this is agreed, the only criterion that is at play here is that last one about the character of the relevant locality and so on. So it's a sort of open question, and there's no presumption either way in this case because there have been two objections. So that's the policy. But it's worth just saying something about Thompson. I agree with Mr. Walsgrove that the way it's put in the objection by Councillor Dunlop is perhaps not as it's not as full as it might have been, and there is a danger that it might lead to a view that isn't an accurate reading of Thompson. Mr. Walsgrove's summary of the facts in Thompson is correct. The position is that where you have an application for a renewal of an SEV licence, it will always be a material consideration, something relevant, that a year ago this council considered that it was worthy of grant. So it considered that there was not a reason to refuse the grant of that licence. Now, of course, in this case, I think it's 16 years, so perhaps this is the 16th year in which there's been an application to licence this premises. Now, that will always be material. And of course, Mr. Walsgrove is also right that if things have changed since the last grant, that will be highly material, particularly in terms of either the character of the locality, if that has changed, as it was said to have done in Thompson, or indeed if things have gone wrong in the intervening year in terms of the way the premises have been run. Now, the corollary of that is that if nothing has changed from the last grant to the present grant, either in terms of the character of the locality, at least in a material way, and in the way the premises have been run, complaints and so on, that too will be a highly material factor in your judgment. But ultimately, there is no prohibition on a council changing its mind. It can do that. That's what that quote from Thompson is really saying, is that your discretion is extremely wide, but you would have, of course, to have a reason to do so. And when thinking about whether to come to a different decision, you would have to explain why, if that was where you were going, having licensed this premises a year ago, and there having been, if in fact this is your finding, no changes in terms of character of the locality or the way the premises run in the meantime, you'd have to explain as a matter of public law why you'd come to a different view. There's no prohibition on doing so, but it would require explanation. So I think the bottom line is, and I hope Mr. Walsgrove will agree with this characterisation of it, is that your discretion is very wide, not limited by any particular rules, save that there are various things which will be relevant to your decision. And if you want to come to a different decision to the one you came to a year ago, there will be a requirement to explain why the change of mind.
That's extremely helpful. Thank you very much, Jude. I hope it was helpful for subcommittee members as well for clarification.
Yes,
Thank you.
definitely. Thank you.
So, with regard to, are there any questions for Mr. Well, we'll hear from Mr. Jala. If there's anything he'd like to add, actually, before we go to questions. Is there anything you'd like to add, Mr. Ajala, with regard to the application?
No, I think John has put forward enough evidence for us. I'd just like to mention one thing that Sarah Rogers said about her visit, that the alarm system at the time wasn't working. The system itself was working. It showed it was bleeping because there was a fault on the panel, but the system itself was fully operational. Thank you.
Thank you very much for that. It's just important that out of that, the visit was made, which is there for the purpose of making sure everything's safe, and indeed it was. So we're grateful to you, also grateful to Mrs. Rogers with the police for carrying that out. So are there any questions then for Mr. Walgrove? Members, Councillor Williams?
No, thank you.
Councillor Bagwell?
No, thank you.
Okay. I have a question with regard to something which was said in the submission from Councillor Northover. It's a question of issue, and it's whether you had any comment about this or whether it was relevant in any way, shape or form. But she says, I've witnessed the club breaking its licence conditions by having a dancer leaflet businesses and people local to the club whilst wearing a branded jacket. So is there any comment with regard to that? Because we have this as a point of reference from Councillor Northover. We have no idea whether that's the case or not. Thank you, Mr. Walker.
Thank you, Chair. In relation to that, we don't accept that has happened. We don't
Sorry,
accept.
I hear you.
We do not accept that it's happened.
Okay.
We don't agree that that has ever happened because, of course, Mr. Ocean knows the conditions on his licence, and he says he has not breached any of the conditions on his licence.
Okay, thank you very much for that. Councillor Bagwell? Sorry, 1 moment. Yeah, we'll cover that in the application from the councillor. All right, thank you very much. Thank you, Mr. Walgrove. Are there any questions now with regards to Mr. Walgrove's submission on behalf of his client? Councillor Dunlop, I'm afraid I've had notification that she's unable to join us due to a family illness. I'm really sorry to hear that, Councillor Dunlop. I hope that all is well. We do have Councillor Northover who will put forward her presentation, but we will be certain I will read out, in fact, it's rather long, but I'll read it out so that the public are aware of what's been said, and we'll ensure that we do raise questions on your behalf in your absence, Councillor Dunlop, for the purposes of today's hearing. So, Councillor Northover, do you have any questions of the applicant with regard to his submission? Thank you. You have the floor.
I'm not sure if this is the right point to ask about. One particular thing that I think I've mentioned before is the layout of the women's toilets. Is this the appropriate time to ask about that?
Yes, of course.
Yeah.
Ask anything you feel is relevant, Councillor Northover, you can raise. Okay.
Okay, so I'm interested to know, when I did come and visit maybe 2 or 3 years ago, I found the layout of the women's toilets to be quite shocking and quite a serious safeguarding risk. And I wondered, is that something that's changed, or is it still the case that a woman has to go through the men's toilets and then find a door that is the women's toilets within the men's toilet? Is that still the case?
Thank you. If you'd like to answer, thank you, Mr. Walsgrove.
Yeah, so the premises hasn't changed for the last 16 years. So that has always been the case, where there is effectively that entrance door and then a separate entrance door for the ladies' toilets. But my instructions are that there is always a member of staff there to ensure the safeguarding, to ensure that ladies can use the facilities safely. And the licence has been renewed every year for the last 12 years, and the premises has been in operation for 16 years. Yours is the only time it's ever been raised as a concern, but those are Mr. Hodger's instructions that there is a member of staff there to ensure those issues, those safeguarding issues that you've raised.
Thank you, Mr. Wellsgrove. Covers a point I wanted to raise as well. Councillor Northover, any further questions?
No, I will speak later though, will I?
Oh, yes, of course.
Yeah,
You'll have your opportunity to make your representation. Don't worry. Yes,
Yeah.
and I will never allow anybody not to raise a question should they so wish, even if it doesn't fit with our process of speaking.
All right.
This is just for ease for me. Okay.
The only other comment I would just like to point out is that I have actually seen the lady from Wiggle in the branded jacket handing out the flyers with my own eyes. I went over and then I took a picture of the flyer that she had taken into one of the takeaways.
Councillor Northover, I think actually you're absolutely right. You can pop this in add this to your submission that you've already made as an extra. I think it's more appropriate there because you're making more of a statement than a question. We do want to keep questions so it's crisp, okay? But make a note to make sure you do raise whatever it is you need to, okay? Thank you very much. Councillor Williams, yes, of course.
And can I just ask Mrs. Rogers, did you have any issue with the latest toilets?
Mrs. Rogers, would you answer, please?
Yeah, no, the toilet situation has been like that since the premises were operating as the cabaret restaurant when they converted from what was the registry office. So when that operation took over, it was very new and different to have unisex toilets. And all the way through, the dancers themselves do have their own private toilet in their locked dressing room.
Thank you.
Okay, thank you very much for that. So, if there are no further questions, we'll just ask Mrs. Rogers, do you have any questions for the applicant with regard to any of this, if you wanted to tease anything out?
No, fine, thank you.
Okay, thank you very much. So it's now your opportunity, Councillor Northover, with regard to other persons to make the representations. But what I will do is you are second in line. We have quite a long representation from Councillor Dunlop. As she's not able to be here to deal with it herself, I think it's only fair that I read it so the public understand it and that we all have a verbal hearing of it. Are you content, members? Yes? Okay. Okay, so this is Appendice 3. And it's the objection of the renewal of Wiggle sexual entertainment venue licence, and it's from Councillor Dunlop. And remind me of Councillor Dunlop's ward, please, Councillor Northover.
I think it's Moordown.
It's
Moordown, I think.
Moordown. Okay, that's handy. And Councillor Dunlop is from the Moordown ward, which is not near the area or locality. No. Okay. So as a portfolio holder for culture and vibrant places, it is my view that there is no place within Bournemouth, Poole or Christchurch of which it could be said that it was suited in a locality in which it would be appropriate to licence a sex establishment. I wish to object in the strongest terms to the renewal of Wiggle's licence and ask the committee to refuse the application for the reasons stated below. Cultural strategy. The Cultural Compact is about to begin the development of a 10-year cultural strategy for the BCP area. It will encompass all aspects of culture, arts and heritage. The direction of the nighttime economy and range of venues will be considered within this strategy, which will reflect BCP's world-class ambitions. As the portfolio holder setting the vision, I can say with absolute certainty that venues which profit from sexual exploitation and promote a harmful sexist culture are not compatible with being a world-class destination. Locality of Wiggle. Despite efforts by the council to make the area safer, Horseshoe Common and Christchurch Road suffers from ASB. The common itself has proven to be unsafe and attracts the sort of behaviour not welcome anywhere in BCP. Low-end establishments exacerbate this. Two SEVs ensure it is firmly on the bottom rung of the nighttime economy. This is especially disturbing to nearby residents. ASB and poor behaviour can be designed out by revitalising the area in a way that will attract families. Bournemouth markets itself as a family destination. SEVs do not support that ethos and have a damaging and downgrading impact on any area they are to be found. Within Vibrant Places, I have an aspiration to create a cultural action zone in the Horseshoe Common area to make it a safe place for visitors and residents, in particular to attract young people and families. A change of identity will percolate into Christchurch Road and slowly bring about a change of the area, attracting a different crowd. This will drive up the quality of the area so that residents and visitors can enjoy a safe and pleasant environment. SEV clientele are the complete opposite of the visitor we want to attract, not just to this area, but to the conurbation. And exploitation-based businesses should not be removed. I think that might mean should be removed, but it does say should not be removed, but that doesn't really make any sense. There is certainly no place for them in an area that will be designed for families and young people who need positive role models and messages. And this is inverted commas, a quote, and it's from Colvin QC. You have to make a value judgment. That's why you are elected. The law states that you can refuse simply because the venue is in the wrong place. Now, we've already heard advice that that is not the case, members. Public sector equality duty. BCP Council has a duty to take into account the impact of their decision on human rights and protected groups as defined under the Equality Act. Those subject to the equality duty must, in the exercise of their functions, have due regard to the need to eliminate unlawful discrimination, harassment and victimisation and other conduct prohibited by the Act. Advance equality or opportunity between people who share protected characteristics and those who do not, and foster good relations between people who share protected characteristics and those who do not. That is agreed. We do hold that duty, members. Lap dancing clubs are in direct contradiction with equality between men and women and normalises men's sexual objectification of women. Their operation has a negative impact on women and girls as a sex class. Activities within the clubs are detrimental to gender equality, e.g. the stimulation of sexual activity by naked female performers on the floor of the private booths for men's pleasure. The activities within private booths also breach the Council's own SE policy, which states performances must not be lewd. Working conditions and terms of employment of lap dancers are inadequate. Female performers must pay to perform, pay for costumes, whilst male door and bar staff have employment rights. Having due regard for advancing equality involves removing or minimising disadvantages suffered by people due to their protected characteristics, taking steps to meet the needs of people from protected groups where these are different from the needs of other people, and encouraging people from protected groups to participate in public life or in other activities where their participation is disproportionately low. Women who already feel unsafe in the public realm avoid areas where lap dancing clubs are situated. The Royal Institute of Town Planning has further drawn attention and concerns regarding the impact of lap dancing clubs on women in the local areas. Evidence shows that in certain locations, lap dancing and exotic dancing clubs make women feel threatened or uncomfortable. The genuine concerns expressed by women in 2 consultations should not be dismissed as moral objections when they are clearly issues of safety, equality and discrimination. SEVs exploit the economic instability of women and obstruct progress towards equality, being women and men. Their equality impact, which is negative, cannot be mitigated. How is the Council's endorsement of men buying sexual services from women through licensing and relicensing of SEVs advancing equality between the sexes, and how is this giving due regard to its PSED? The link between sexual objectification and violence against women. Hundreds of women organisational work every day with the end result of socially entrenched sexism, namely domestic abuse and sexual violence. In the national and international women's sector, there is no doubt that the sexual objectification of women as practised in SEVs is directly linked to the incidence of sexual and domestic violence. To be clear, this is not a matter of opinion or conjecture. The link between the objectification of women and discrimination and violence towards women is recognised at an international level by the legally binding United Nations Convention to Eliminate Discrimination Against Women, which repeatedly calls upon states, including the UK government, to take action against the objectification of women. The End Violence Against Women Coalition research evidences, and I quote, or Councillor Dunlop quotes, that girls face intolerable levels of harassment in schools on a daily basis. Access to pornography while at school is commonplace and nude images are traded like football stickers. Outside the classroom, abuse of women and girls continues at alarming rates in our society. 2 women are killed each week by partners or former partners. Almost 500,000 rapes and sexual assaults happen each year in England and Wales. This is with regard to domestic violence. It is not with regard to this particular premise. I need to make that clear. The normalisation of porn culture and the objectification of women as a sex class is apparent every day in our society. Lap dancing clubs normalise the representation of women as being always sexually available. The links between the expansion of lap dancing clubs and an increase in the levels of sexual violence have been raised by organisations who work with victims and perpetrators or gender-based violence. Strip clubs promote a harmful sexist culture. They promote a profit from sexist attitudes that pave the way for misogyny, male sexual entitlement and male violence against women and girls. We cannot tackle male violence unless we address the sexist culture that underpins it. How can BCP hope to eliminate sexual abuse and violence against women and girls if its licensing authority supports this harmful sexist culture of dehumanising and objectifying women and girls and normalises the buying and selling of women's bodies? And then you can say no. SEV's licensing legislation is entirely separate to the Licensing Act. That is to say, the 4 licensing objectives have no relevance to SEV policy or an application to license or relicense a SEV. Councils have sweeping powers to refuse to relicense on the grounds of locality. This is regardless of any change in locality or any other material changes whatsoever. We've heard advice with regard to that point. This has been widely confirmed by case law judges and other experts. Furthermore, operators have no legal grounds to challenge such a decision. We've also heard legal advice on that point. Those that do must go to the High Court, a very difficult route. None have ever succeeded. Frequently, the case is instantly dismissed without being heard. Strip clubs have no legal grounds to challenge a decision, not to resilience. Licensing authorities are entitled to have a fresh look and may refuse to relicense even where there has been no material change in circumstances. That again comes from P. Colvin. Despite the current SEV policy attempting to fetter the committee's powers by giving existing clubs acquired rights, the law says that pre-existing clubs cannot be treated differently from new applicants. Again, we have heard legal advice, or we have been given legal advice with regard to that point. Parliament has drawn no distinction between grant and renewal of a SEV licence. To make a distinction would fetter the discretion of the local authority in cases of renewal, which Parliament has not done. Thompson v Oxford City Council, the statute imposes no constraint upon a local authority's discretion when it is considering a renewal. In my judgment, it is not perverse to refuse a renewal where there is no change in the character of the relevant locality or in the use to which any premises in the locality are put, and that's Thompson v Oxford City Council, of which we have also heard advice from both of our briefs with regard to the applicant and the council. Please take the lead from other councils who are taking action by refusing to license these harmful clubs. Note, Philip Colvin QC is the legal authority on SEV licensing. He wrote the legislation. He did not write the legislation. That was written by the government, certainly not by himself. So I think that is an end to the statement. So it was a bit long, but I think it's really important that the public do hear it and understand it. Sorry, I just need to get rid of that. With that heard then, we now have the opportunity for you, Councillor Northover, to make your representation. Thank you very much.
Thank you. I've got a few different points. The first is that I think the area has changed since 2006 massively, and in several ways. One is that the number of student accommodation blocks that have been built means that there's hundreds and hundreds.
Sorry, Councillor Northover, did you say 2000? Was that the date you gave? 2006?
2006. I think that's when somebody said that this was first licensed.
Yeah.
Yeah. So there's hundreds and hundreds, possibly thousands of students now living in the town centre, very near to this place, that weren't there when this was first given a licence. There's a lot of new, just normal flats as well that have been built since then. The Citrus building is really near. There's families living in there, so there's children living now just a minute away from this place that weren't there before. There's a lot of new restaurants since COVID finished. I've noticed that there's a lot of new sort of cafes. There's a place opposite this venue that is like a big patisserie. And these are, I would say this is a change in how that area is changing. That sort of place, a patisserie, which isn't alcohol-led, is something that previously everything pretty much was alcohol led. This is, I think this is a real change. And so one night I did walk down from the square up to eventually past Wiggle, and there's a lot of big families out there having meals, and this was getting on for quite late in the evening. Well, there are, I don't know why you're looking like that. There are, I've seen them. And I walked past lots of restaurants with big families, and then I came across outside Wiggle this woman flyering, wearing a Wiggle branded jacket and giving out flyers. I can't see how you can not be aware of that, because they're printed. Like, I can't see how flyers are getting printed if this isn't something that's taking place. So the next point I wanted to make is about the police not objecting on bringing up crimes related. And I think the issue here is that sexual harassment in the street, somebody shouting something at you like, will you get your tits out and I'll give you £20, is not something that's really reportable to the police. So it's a low level activity that puts women off walking past there. It's not that somebody's going to come along and do something that means you can call 999. It's the way that the area feels. And we know that the men who are going into Wiggle are going in there and paying for dancers so they can become sexually aroused. That's the whole point of it. So when they leave, having also drunk quite a lot, they're frustrated and they do take it out on other women who are in the vicinity. And I've had this happen to me, so I know that it happens. It's not a moral objection. It's I don't want to be spoken to like that by people that have just spent a couple of £100 in Wiggle getting het up. I don't really see how that can be prevented other than that activity not happening in that place. And I think I had a look at the website earlier, and there's stuff in place to make sure the dancers are safe leaving, like they're escorted to the taxi. So there's a recognition there that there is an issue with men bothering women who are coming out of Wiggle. So why would that apply to the dancers but not the general public? Other women are affected. You don't have to be working in there to be affected by what's happening to the men that are coming out of there. So I think women do avoid the area, and I don't think it's right that there can be an area within our towns that is avoided that women avoid. I can't see how that meets the requirements under the Equality Act. I just want to say again about the toilets, because I find it like astonishing that this is okay to have a toilet set up like that. I can't think of any normal bar or club that has a toilet set up like that. And perhaps it was an oversight when the first license was given, but it seems really bizarre and unsafe to me, and that it then has to be reliant on a security guard to make sure that it's kept safe. It should be designed so it's safe. And then just lastly, I just wanted to say that as a town, is this what we want to be known for? That it's somewhere where you can make this sort of purchase, and what does that say about how we value women? Yeah, so those are all my points. Thank you.
Thank you, Councillor Northover. There was a lot in there. Thank you for taking the time to explain that all to us, and be clear with regard to your own personal concerns with regard to the experiences that you're advising us that you've had. Thank you for that. It's now an opportunity. We've heard from Councillor Dunlop. She can't be here, obviously, herself. It's now an opportunity for questions of the other persons, and I begin with members. I'll kick off if that's okay, members. Yeah, I have quite a few questions. Clearly, you tell us that you were accosted by one of the male attendees at the club, and that this was very upsetting, and that you were very upset. Did you feel that it was appropriate for you at the time to call 999 if you felt threatened, or perhaps at a later stage with regard to your concerns, especially about the duty of equality for women to feel safe? Did you report it to 101 so that they had a record of your concerns, your particular concern at the time? Thank you, Councillor Northover.
No, I don't think it realistically would meet a threshold to even be reportable in my mind, and perhaps it should, but comments, I certainly not 999, and I don't really think it's the sort of thing that people do report, and I didn't even think to report it, so no.
Okay, even though you have obviously a huge knowledge in this area, especially with the equality duty with regard to the women feeling safe in this area, you didn't feel at that time, having felt, as you told us, threatened and uncomfortable, that it was something you'd want the police to know about, which is possible. It might not have been a 999 call, I grant you that, but something that you would have reported in the quietness of your own home when you'd had a little time to think about it, perhaps on the 101 facility, which is available to all residents. But you didn't feel that that was appropriate.
I didn't think it. Okay,
that's fine, Councillor Northover. Thank you for that. That's fine. The question of the toilets. Could you take us again? You visited these toilets. We haven't seen the toilets, okay, so we don't know what they look like. We didn't do a visit. It's not planning. But could you give us some idea as to the layout? Talk us through it when you go into the club. You want to go. You're in there for some reason, right? And you need to use the ladies. So take us through it.
So as I remember, you go in through a door, there's some urinals and well, you can correct me if I'm wrong afterwards. There's some urinals and a cubicle or two, and then you go through a door within that room, and that's where the ladies is.
Right. So
you have to walk past, unless it's been changed, you have to walk past men who are urinating using the urinals.
And we heard from the applicant with regard to how that is dealt with, because this is a unisex toilet setup, which in law is acceptable. Oh, sorry. I don't think that is. Can I finish my question?
Sorry.
Can I finish my question? We did hear with regard to something about unisex. Obviously, girls aren't going to use the urinals, so that unisex can be available. It may not be available in this case, but what they've done here is they've done, you walk through the gents, you go to the ladies. But we've heard that there's a security guard to keep safe. Now, I think you said to us you felt that it shouldn't be a security guard that keeps it safe. So you believe, I think, that it is safe, but you would prefer it to be designed so it was safe. But you weren't questioning that it wasn't safe once you'd heard that a security guard was there to keep it safe. Is that the case?
I suppose so, yeah. I mean, it would only need the security guard to need to go and do something. They could decide not to have a security guard anymore. I don't know if that's a condition on their licence.
Yes, well, indeed. So thank you for explaining the interior layout. That was very helpful. Yes, indeed. I'm going to leave it there because Mr. Cannon, you would like to intercede. Thank you very much.
Well, thank you. Only to say that I think the proper way to deal with this is, first of all, I think to give the applicant an opportunity to just respond to. I shall do.
Yes, I shall do, Mr. Cannon. No fear of that.
Sorry, just on the point of fact, which is the layout. Obviously, Councillor Northover is giving a recollection, which is entirely proper. It may well be that Mr. Ojla has a different view, but I understand also that Ms. Rogers has the licensed plan of the premises, which might also help. Now, I don't mind when that happens. I don't think there's a particular need for that to happen at a particular time. But I think given that there's a sort of question about exactly what the layout is, you ought to get to the bottom of it in that way, having heard both from Councillor Northover and also from the applicant, whether by themselves or through Mr. Walsgrove.
Thank you, Mr. Cannon, and my apologies because you were attempting to advise me of that, but my phone was disconnected and was not working. Thank you very much for that. I shall indeed do that. Okay, lovely. Thank you. Mr. Walsgrove, would you please like to come back in now at this juncture and take us through that particular part of the matter with regard to your toilet provision? Thank you.
I think it's better if Mr. OJ gives his description of how people use the toilet.
We do have a plan, do we not?
So Paul or Tarek, if you would like to just describe how that operates, that would be helpful.
One moment. Mrs. Rogers, you telling us that we do have a plan that can be sent?
Yeah, well, I have it up on my screen. If you want
You
to
could share it,
my
please, if
screen.
you would. That'd be really helpful. And then Mr. can take us through it. That would be lovely. Thank you very much.
Share my screen. Share my. Oh, it won't let me.
Just Mr. Tyler will see if he can help us. The best hearings are the ones that don't run smoothly, I always think.
It's not letting me share my screen.
Mr. Tyler was attempting to do it.
Oh,
we
yeah.
should be able to now,
Yeah,
Mrs. Rogers. I think it was a permission you needed.
There you
Oh,
are. Can you see
great.
it?
Right, thank you very much. So
this is the
it's
stairs.
small, but we'll pier. Yep.
This is the first floor. So you come up these stairs from the ground floor, and the entrance is here, and then this is the toilet here.
Where's your arrow? Could you point? Could you wiggle it? Oh yes, I see. Yeah.
You come up the stairs, and then there's a lobby here. This is office. This is the staff changing room with their own WC here. This is a locked door, and then the entrance to the toilet is here, and it's lots of cubicles here. So they're shut doors.
So there are no urinals.
I think this is the urinal area. Correct me if I'm wrong, but I've never gone in it. There's a door here, and then these are the urinals, but these are all closed cubicles.
Okay, thank you very much. Mr. Ajala, would you like to take us through it, please, and explain exactly what's what, so you'll be very familiar with this. Thank you, Mr. Ajala, when you're ready.
Yes, certainly. The toilets are completely separated in where the gents' urinals are. You cannot see into the urinal area because there's a door there as well. The gents' cubicles are in front. Again, as Mrs. Rogers has said, there are sealed doors there, and the ladies' toilets are to the left of that. Where the wash hand basins are there's always a cloakroom attendant who's always there, and he's still there each night now. So it was a modern way of doing things in the early, sort of mid-20s, late 20s, and at quite a few restaurants that we did it at the time because it was the trendy thing to do. But females are very safe in there because 15 to 20% of our customers are females.
That's really useful. Thank you so much for taking us through that. And now we've had absolute clear evidence as to what's what and the complete layout and how and the functionality of it and the security guard in place. Thank you very much, Mr. Ajala. And thank you very much, Mr. Cannon, for your reference to make sure that we ask the right person the right question. We're extremely grateful to you for your guidance. So with that said, we are at the moment asking questions of other persons. So members, do you have any further questions for Councillor Northover at this time? Oh, Councillor Williams has a small question for you. Councillor Northover, thank you.
Councillor Northover, as a councillor, I usually carry a mobile phone with me. I'm pretty sure you probably do too. Did you not think to take a picture of the lady handing out leaflets?
Thank you.
Thank you.
Thank you, Councillor Williams. Did you manage to gather any evidence, Councillor Northover?
No, I just I went over to see where she had put some of the leaflets, and I went and got one. I showed it to Councillor Dunlop, and I think she sent it through to licensing, but I didn't feel comfortable to take a picture of the lady because it felt a bit aggressive to do that.
Ms Rogers, could you confirm or not that the photograph was sent, the leaflet was sent to you by any chance?
I don't recall it, but I can check through and see if it's been recorded. I'll have a look now for you.
Thank you.
Any further questions, Councillor Bagwell?
Yes, thank you. We haven't heard that any residents in that area are complaining about Wiggle. So if the residents aren't complaining, how are you getting your info that there's a lot of angst about the premises?
Thank you, Councillor.
Councillor Northover, sorry.
You, Councillor Northover. Thank you, Councillor.
Yeah, I think I'm quite interested in this issue, and even I miss the applications because they are quite easy to miss. And I think the town centre, women who are in the town centre, because it's not something that is outside their house, I think it's quite reasonable that they wouldn't think to make an objection. And it's quite hard from if you want to find out about somebody's licence, it used to be that you could go and look at their licence on the BCP website, but you can't do that anymore. So it's quite difficult to actually see what it is that is being renewed anyway. You can kind of go to the trouble to try and find out, and it might just be something very, very minor, or it could be that it's renewing a whole set of circumstances that you don't agree with. It's not very easy to find that information. I find it, even as a councillor, quite hard to see what is being asked and what it is that is being renewed. So, yeah.
Thank you, Councillor Bagwell. You got a question?
So surely, Councillor Northover, if there was complaints, even if they didn't see the licensing renewal online or wherever, because I do appreciate our website is difficult, they surely would have been able to contact our officers who are really hot on the ball on reading complaints and information that comes to them. And also the police, they're there to protect the public. If there's no complaints from the police and the officers haven't had complaints sent to them regarding the club and the people that go there, then surely, unless we have evidence, we can't really do very much about that. So, but thank you for your input. It's really helpful.
And I think I'll add to that, Councillor Northover. I think that was a general statement which was useful. But I think with regard to the access for information for councillors, I made absolutely sure when I was made chair that the same balance was given to all quasi-judicial committees. So all planning applications that are going to occur are printed on a regular basis, and we have exactly the same for licensing. It goes out to every single councillor. It's very useful because councillors are able to identify what's going on in their ward and can make application. I'm not certain if you might have in fact used that yourself to have identified that the Wiggle application was coming up. Otherwise, I don't know, you may have seen a notice, or it may have been general information in the locale, I don't know. But there is easy access for information, and once that item is identified as an application that may be of interest to you, you are completely free to speak to the licensing team, who are always available to assist you. So that's just to say, in future, please know that that is there for you. The applications are in fact printed out on a regular basis as they are happening. So there should be no reason for any councillor not to be able to provide their resident with the information they need. I hope that's helpful. Are there any further questions? No. Okay, thank you so much, Councillor Northover. That probably sounded like a grilling, but we're trying just to get to the bottom of everything, and we're extremely grateful for all the points that you've raised. Thank you very much for coming along and raising them. You will have an opportunity in a minute to sum up and cover all the points that you'd like to. Okay? Is that okay, Councillor? Thank you very much indeed. So are there questions then of any other persons with regarding to this? And that is Mr. Walsgrove. Do you have any questions for Councillor Northover?
No, thank you, Chair.
Okay, thank you. And Mr. Ojala, do you have any questions for Councillor Northover?
Yeah, thank you, Councillor, for raising your point. I'd just like to make clear some of the ways that we operate as a company. Wiggle Bournemouth has operated, as we know, for many years. It's enjoyed by many people. Bournemouth's got a thriving nighttime economy.
Mr. Ojala, if I just stop you there, bless you. If you have a specific question for the councillor, you can assist us with regard to what you have to say now in your summary. Be very happy to hear that. It's just if you have a specific question to Councillor Northover with regard to her concerns that she's raised in front of the subcommittee this morning. Thank you.
Okay, I'll cut to it then. With regard to safety, where she raised about that we offer a taxi escort to our performers, this is something we offer to all customers that leave our premises. Male, female, all customers are offered a taxi escort, something that we take pride in, that we do offer that service to all customers and members of staff.
Thank you, that's extremely helpful, and I hope that gives some assurance also to Councillor Northover, who raised a very good, very salient point. Thank you very much. Mrs. Rogers, do you have any questions or with regard to this issue of Councillor Northover?
Yes, I've just found there was a complaint. It was sent in by Councillor Dunlop in September 2021,
right.
And it was with members of staff wearing wiggle gilets and handing out wristbands to premises opposite, two takeaway premises opposite, and they there was a recording which is no longer saved on here for some reason from the staff in one of the takeaways saying that they'd run out of these half-price promotion wristbands. It looks from the complaint that it was something that all three of these clubs were doing. So with legal advice, we wrote to all three premises to remind them of the conditions with regard to advertising. And they, as far as I was aware now, that has ceased.
So the matter was reported, and have you satisfied yourself that you dealt with it accordingly? And it was all three clubs were doing this as a group?
Not as a group. When we looked into it, there was advertising taking place from all three of them in some shape or form. So we wrote a generic letter to all of them, reminding them of the need to comply with advertising requirements, and we haven't had a complaint since.
Okay, thank you for that. Councillor Bagwell, would you want to say something?
Thank you very much for that input. It's really, really good. And I'm really glad to see that all premises were written to, all are abiding by it, and it was wristbands given out as a promotion and things. So thank you ever so much, Sarah.
Thank you. I'm happy with that clarification, because Mr. Walsgrove told us that it was not a leaflet, and indeed it was not a leaflet. Yeah. It was in fact a wristband. I don't know whether Mr. Walsgrove or Mr. Ojala would like to just comment on that for completeness with regard to that particular matter, as it is actually a point of fact. Mr. Ojala?
Yeah, if I could just deal with that point.
Oh, Mr. Walsgrove, thank you.
Yeah, Yes, there are promotional wristbands, but certainly the instructions prior to the complaint and at all times are that they are not to be effectively walking around the locality and handing them out to people and trying to encourage people to come in. They are only supposed to be given at the venue itself. So as a person might walk past Wiggle. So, excuse me, if that had happened, then that staff member was acting outside the instructions that they had received. And as you've heard, obviously, that each of the premises had to be warned about that. And Mr. Odgel obviously constantly reminds those who are employed by him of the conditions on the licence. So we weren't aware of the nature of the complaint other than the follow-up letter. And all I would say is that, you know, Mr. Odgler wasn't aware that his staff had breached the condition because he ensures that they don't go around the town distributing the wristbands that he has as a promotion, which he also has at all his other clubs.
Right, thank you, that's useful. I'm just going to pop back to Councillor Northover, just a point of clarity. Did you say that you took Councillor Dunlop said she took a photograph of the leaflet, or was it a wristband, or was it just a little bit of grey area there?
Yeah, I think you're right. I've misremembered. The reason I'm thinking it was a leaflet is because the way that they're printed, it does produce it. They're like strips that are all stuck together. So it is like an A5 sheet of lots of wristbands, and then you tear them off, and that's.
I understand. So it's the American clip way where you rip off a strip from the bottom. I understand, yeah. on a sheet. So it looked like a sheet, but in fact they were just getting a small part of it. Okay, that's really helpful, Councillor Northover. Thank you very much for that. So no further questions from you, Mrs. Rogers, for Councillor Northover?
No, thank you, no.
Thank you very much for everybody's input there. That was extremely helpful. So now we move on to summary, and the party who spoke last to go first, we don't have Councillor Dunlop with us, so we'll go to Councillor Northover, and if you'd like to summarise, Councillor Northover, thank you.
Okay, I think
if you don't want to, you don't have to, but if you'd like to, please go ahead.
Just a couple of points I'd just like to clarify. I think when I'm talking about people being escorted to the taxi rank, and fair enough, keeping the customers of Wiggle safe is one thing, but my concern is more about other women who are in that vicinity, and I can't really see that there's anything the club can do to keep those women safe. But I don't see why they're not just as at risk as women who have just walked out of that club. Once they're outside, there's nothing to distinguish between one and the other. So I think by understanding that there is a risk, I can't see why you can't see that there's a risk for other women who are just in the vicinity. Just a point I wanted to make about the availability of the people's licenses. Unlike planning, where you can go and see all of the everybody's planning applications and whether they've been approved or not, going back maybe decades, you can't do that with licensing. You can't go back and look at what license somebody has. I'm pretty sure you used to be able to, but I can't find that on the website anymore. And just to make a point as well, if the wristbands are printed so that the right use of them, I think you said was, Mr. Walsgrove said that they would be given to people who are passing by the club, but I think that's against the conditions. So if that is why they've been made, then I don't know what the legitimate use is, but I think you've said that they're for people to hand out to people as they pass by, which I think is equally not supposed to be happening. That's all of my points.
No, I think you misheard there, Councillor Northover. What Mr. Walsgrove said, as far as I was understanding, the panel, if in agreement there, was that there was inside the premises, certainly not outside the premises, because that would be a breach of condition. So it was within the premises for the clientele who are already in there, would be handed a a wristband. I don't think I heard that it was outside, but I could ask Mr. Walgrove to confirm. Mr. Walgrove?
Your understanding is correct. I can't remember the word I used. I may have said at the premises, but at the door, not walking around the street outside trying to encourage people in. No.
That was our understanding of what you said, Mr. Walgrove. I believe panel. Yes.
Yes.
Yes. Okay. Thank you. Thank you very much, Councillor Northover, for your summary. So moving now to Mr. Walsgrove, with regard to summary, you have the floor.
Thank you, Chair. I'll just firstly pick up on a point made about the absent complaints from local people.
Would you like to put that in your summary rather than answer a point in case? I'd be grateful.
Yes, this is my summary. It's the first point of my summary. So in my experience, I've been doing licence 30 years. If people have got a problem with licensed premises, they tend not to go on anybody's website. They're either phoning the council licensing team, going to the council and speaking to them, speaking to their ward councillors, or phoning the police. They do one of those things, and people are not doing that. So nobody seems to have got in touch with either of the councillors to raise concerns. No one's got in touch with licensing, and nobody's got in touch with the police. So, you know, I ask you to attach weight to that this premises is not having any negative impact on its locality and the amenity surrounding it. So I ask you in summary to attach weight to, firstly, having due regard to the fact that the premises, the SEV licence, has been renewed every year for the last 12 years, but has been there even longer, since 2006. I ask you to have regard and attach weight to your policy that the existing premises are to be considered. And I know you've had legal advice on the policy, but the policy is clear in terms of identifying Wiggle as one of those premises where the licence will be renewed, subject to reconsideration of the discretionary ground. And I ask you to look at the representations that have been made and take them for what they are. And they are objections based on moral grounds, because the two councillors who've objected do not want an SEV premises in Bournemouth. They haven't raised, in my view, specific grounds as to the impact this particular premises Wiggle is having on that locality. They are basically saying Bournemouth should not have SEVs in the council area, and that's not right. You have to consider just Wiggle on its merits in its location, and my clients adduced evidence that the current character of the locality hasn't changed in the last 12 months. There is credible evidence that the premises is run responsibly, given that it's been there for so long. And in terms of the Thompson case, I entirely agree you have an unfettered discretion, and that wasn't the point I was trying to make from that case. It was the fact where, having come to a different decision, they clearly had very credible evidence as to why they could make that different decision. And what I'm saying to you is the two councillors who've made representations have not put forward anything credible that you could hang your hat on to say, well, that's why we reached a different decision. All you've got before you is evidence that this is a very well run premises, and that there aren't any issues from any people living in the local area, whether residents or businesses. So I ask you to renew the licence for a further 12 months. Thank you, councillors.
Thank you very much, Mr. Walsgrove, and I'm really grateful for clarification on that last point again. I think we've suddenly had a dawning as to what that point meant. It's very, very useful. Thank you very much. So then asking Tanya, sorry, Mrs. Rogers, or Mr. Ojalas, I'm sure I'm pronouncing your name incorrectly. I do apologise. Do you have anything to add? It's your opportunity to add something now.
Yes, thank you. We've operated venues for so long, and I believe in what I do, and we've always abided by all the rules, all the conditions, and I intend to do the same in the future. Thank you.
Thank you very much indeed. Thank you. And Mrs. Rogers, did you wish to summary or advise in any way?
No, my thanks.
Okay, thank you very much. So thank you very much, everybody, for your contributions and for the information which you provided the subcommittee today. I'll now conclude the hearing, and the subcommittee will adjourn in private with our legal advisor, Mr. Cannon, and our clerk, Mr. Tyler, and we're going to do that directly after we complete this meeting. And notification of the subcommittee's decision will be provided within a period of 5 working days, beginning with the day or the last day on which the hearing was held in accordance with the regulations, which is today, and that is Thursday, the 26th of May. And notification of the decision will include information about the right of appeal as appropriate. And I'll just ask our legal advisor, Mr. Cannon, if he'd kindly take us through explain the right of appeal. Thank you, Mr. Cannon.
It might be better to do that with the decision, I think, rather than now. I'm not sure there's anything particularly gained by going through that at this stage, but that will accompany the notice of decision when it comes out in writing, which I think is probably a better way of doing that.
Well, with respect, we always at this stage give a very brief overview of the rights with regard to the 21-day period. It's not the whole explanation, Mr. Cannon. So for a point of reference, I'd be grateful if you could just give us a brief reference to the 21 days. Thank you.
Yes, well, beyond what you've said, appeal rights where they arise, I would need to check this actually, because there are certain grounds which are only challengeable by judicial review. I think the 21-day thing that you're referring to, and I don't want to embarrass anybody, not least myself, is from the Licensing Act. So I think we do need to be a bit careful here, because there are different, in fact, appeal's not even the right word, but different routes to challenge different decisions depending on the grounds on which they're made. So I think, if I may, I'm going to demur again, and we'll put...
And I will agree your demur. As you so rightly say, it's the Miscellaneous Provisions Act, isn't it? It's not the Licensing Act. So I think we need to look to what provisions sit under that. So you win. Yes, indeed. Thank you. We'll look to that advice in the written advice. Thank you very much, Mr. Cannon. So thank you very much, everybody, for attending and for your contributions. We would ask everybody who to now leave the meeting, and we will get that decision to you within the prescribed time with the appropriate legal advice with regard to any right of appeal, if that is so necessary. And we'll now go away and consider carefully what we've heard and give you our decision. Thank you very much, everybody. If I could ask Mr. Cannon and Mr. Tyler to stay with us. Thank you, and good morning to you. Thank you. Goodbye.